Hello friends, today we are going to discuss about DPSP and the fundamental duties. This is unit 6 of Ignou BPSC-132 Indian government and politics. So let us start. So DPSP and fundamental duties. The full form of DPSP is Directive Principles of State Policy, and we have borrowed this idea from the Irish constitutions. So what is the speciality of DPSP is that these directives, principles of state policy are so fundamental for the state governance. And this DPSP is there in part 3 of our constitution, ranging from article 36 to 51. Article 36 to 51. Part 4 talks about, part 4 talks about DPSP, and part 3 talks about fundamental right. Part 4, that is article 36 to 51, talks about DPSP, that is directive principles of state policy. So let's get started. So DPSP, actually it is not constitutionally categorized, but for academic purpose we can classify the DPSP into 3 categories. So what are the 3 categories? One is socialist principles, second is Gandhian principle, and third is liberal principle. So socialistic principles are those which are aimed for the welfare state. So many articles are there in it. So you can Google it, or if you have Lakshmikant book, you can search on it. But to get a precise idea only, I am discussing this categorization. One of the important article in the socialist principle is Article 39 clause B and 39 clause C. Article 39 clause B and Article 39 clause C. Why I am discussing these articles? Because Article 39 clause B says the equitable distribution of material resources of the community for the common good. That is, the resources need to be equitably distributed for the common good. And second is that Article 39 clause C says that the prevention of concentration of wealth and means of protection in one particular community or in one individuals, in one group of individuals, that the wealth or resources should not be concentrated in one community or at one individual. So that is what Article 39 clause B and clause C talks about. We are using this article for some purposes in the later slides, because that's why I have mentioned socialist principle. Socialist principle mainly deals with the constitution of social welfare state. Then about Gandhian principle is that Gandhian ideals, the DPSPs which represents the Gandhian ideals. And one of the important article is Article 14, that is Constitution of Village Panchayats. Okay, it is the Gandhian principle. Then the liberal intellectual principle. Last is liberal intellectual principle, and one of the most famous one in this is Article 44, that is to secure a uniform civil code for all citizens. That is what I can say about liberal intellectual principle. So these are the main 3 types of DPSPs which are available, and it is not a categorization made by constitution. This is only made for academic purpose only. I hope you understand this categorization. Now we are moving to the next slide, that is fundamental right versus DPSP. So what is the main difference between fundamental right and DPSP is that fundamental rights are justiciable. That means if any of the fundamental rights are violated, we can approach the court and get our fundamental right restored. But DPSP is not justiciable. That means if any of the DPSPs is being violated, we can't approach the court for its for restoring it. So that is what DPSP looks for. But does this say that DPSP cannot be enforced? Not at all. DPSP can be enforced, and DPSP is enforced in can be enforced by various laws adopted by states as well as the states as well as the central. One of the example is the 73rd Constitution Amendment Act, which constituted village panchayats. Okay, and it is a reflection of Article 14, which is talking about Constitution of Village Panchayat. Okay, so this is also DPSPs can be enforced, but until and unless it is enforced, it is not justiciable like that of fundamental rights. That you need to keep in mind. So I am talking about the fundamental rights, the conflict between fundamental right and DPSP. This is very important, and I think this is not mentioned very deeply in the IGNOU textbook. But if you learn this, I am assuring that you would going to get an extra mark for this chapter. No doubt about it. So let's get started. So first, legal battle pertaining to the fundamental rights, conflict of fundamental rights and the DPSP came in the light of Chambagam Durai Rajan case. Chambagam Durai Rajan case versus Chambagam Durai Rajan versus State of Madras case. So in that, the Supreme Court has held that the fundamental rights, DPSPs are subsidiary to fundamental rights, or DPSP is subordinate to fundamental rights. But it also gave an opportunity that to implement fundamental rights, so to implement DPSP, fundamental rights can be amended by the parliament. It gave the opportunity to parliament to amend the fundamental right if it want to implement some of the DPSP, but it said that DPSP is above the fundamental right. If there is any conflict between the fundamental right and DPSP, the fundamental rights would be prevailing over DPSP. So fundamental right is above DPSP, and in order to break the deadlock, Parliament can amend the fundamental right. Okay, that is what Chambagam Durai Rajan case has told. But in Kolakanath case in 1967, Kolakanath case, it had said that it had actually Supreme Court, in this case, Supreme Court, Kolakanath case, Supreme Court had restricted the unlimited power of Parliament to amend the Constitution, and it said that fundamental rights are sacrosanct in nature. Sacrosanct, it cannot be touched or amended. So the Parliament has no power to abridge or take away the fundamental rights of citizens, even if it is a constitution amendment also. So that much powerfully Supreme Court has stated this in Kolakanath case in 1967. So fundamental rights was far more superior in DPSP. But Parliament has, in retaliation, in response, had passed 24th and 25th Amendment Act. Now, 24th Amendment Act says that the Parliament can amend the Constitution even if it is fundamental rights also. So it is contradictory to that of Kolakanath case. So one thing, okay, this amendment had took place in 1971. Okay, then 25th Amendment Act had added Article 31C to the Constitution. What Article 31C is speaking about is that you need to check into two provisions of this article, that is, no law which seeks to implement the socialist directive principles specified in Article 39 clause B and 39 clause C shall be void on the ground of contravention of the fundamental rights conferred by Article 14 and equal Article 19 or Article 31. It's a legalist term, but for your simplified understanding, you can say that for implementing Article 39 clause B and Article 39 clause C. So I have mentioned this earlier, Article 39 clause B and Article 39 clause C. So what it talks about? Article 39 clause B talks about equitable distribution of resources to ensure common good, and Article 39 C talks about, clause C talks about preventing the wealth to be concentrated in one individual, in the hands of one individual or one community. So these are the two important articles related to this Article 31C, and it is also a part of Dpsp. So for implementing these two articles, that is Article 39 clause B and Article 39 clause C of the Dpsp, so what can be done is that if Article 30, for implementing this Article 39 clause B and Article 39 clause C, if while implementing these articles, if it is in contravening or if it is in contradicting the fundamental rights such as Article 14 or Article 19 or Article 31, please note that Article 31 is not a fundamental right now. Article 31 is a right to property, it's not a fundamental right. So Article, if the for implementing any of the provision or any of the laws which is in conformant, which is in consistent with Article 39 clause B and Article 39 clause C, and it violates fundamental rights like Article 19 or Article 14, then the Dpsp would prevail. That is, Dpsp means Article 39 clause B and Article 39 clause C would prevail. That specific Dpsps would prevail. So that is what the first provision of the Article 31C is talking about. That is, Dpsp such as Article 39 clause B and Article 39 clause C would be superior to that of fundamental rights of Article 14 and Article 19. Article 14 talks about right to equality, and Article 19 talks about freedom of speech, freedom of expression, etc. Now, a turn has come for judiciary to play. That is, in Keshwanath Bharati case of 1973, Supreme Court had partially agreed to Article 31C, because I have mentioned its first provision that in order to implement Article 39 clause B and clause C, what if it is in contravention to the fundamental rights like Article 19 or Article 40, there will be no problem. The Dpsp of Article 39 clause B and Article 39 clause C would prevail. Okay, so it upheld that provision, and a second provision was also there for Article 31C. Sorry for not discussing it. What was the second provision is that this could not be questioned in any court of law. That is, okay. So if the government implements any of the laws according to Article 31C, cannot be questioned by any law, or judicial review is not being permitted by this article. It was being quashed by Keshwanath in Keshwanath Bharati case. It was being held that it is unconstitutional. So the second provision of the Article 31C was held unconstitutional, whereas the first provision of the Article 31C was upheld. Now, in 42nd Constitution Amendment Act, during the Indira Gandhi's government time, in Article 31C, there was an amendment was being brought, that is 42nd Constitution Amendment Act. So what it had brought is that I have mentioned earlier that Article 31C first provision was talking about this, that is Article 39 clause B and Article 39 clause C is far more superior than the fundamental rights like Article 14 and Article 19. Okay, now those Dpsps are only fundamental above the certain fundamental rights like Article 14 and Article 19 I have mentioned. But the 42nd Constitution Amendment Act has increased the scope. It included all Dpsp. So what happened is that all Dpsp would have an upper hand over fundamental rights such as uh, Article 14 and Article 19. But in 1918, sorry, I haven't mentioned that case in the slide. In 1918, Minerva Mills case, this amendment was being quashed or held unconstitutional by the Supreme Court. So this is the journey about fundamental rights and Dpsp. So what is the conclusion we can get? This is a brief history about it. If you don't understand it or if you can't get into it, I have another slide. This conclusion that which is having more priority, that fundamental right except Article 14 and Article 19 have the highest priority. So fundamental right except Article 14 and Article 19, okay, has higher priority. Then second comes the Article 39 clause B and Article 31 clause C of which is part of Dpsp. Then below it only fundamental rights like Article 14 and Article 19 is coming. Okay. Then if and the least priority is given to other Dpsp. So this is what the overall synopsis is of what I have discussed. Okay. Now we are going to discuss about fundamental duties. Fundamental duties was constituted by a recommendation of Saran Singh Committee during Indira Gandhi's government, and it was added to the Constitution by 42nd Constitution Amendment Act. So like Dpsp, it is not justiciable in nature also. So these are some of the fundamental rights. So initially in the Constitution, there were 10 fundamental rights. Now recently it is being said that 86th Constitution Amendment Act had added the 11th fundamental rights also. So 11th fundamental rights. So 11th fundamental rights. So the 11th fundamental rights talks about to provide opportunities by a parent or guardian for education to his or her child, or as the case may be, to the ward between age of 6 to 14 years. So this is being added by 86th Constitution Amendment Act of 2003. So initially our constitution had 10 fundamental duties, and 11th one was added in by the 86th Constitution Amendment Act. Now review of fundamental duties. So we have discussed about 11 fundamental duties, but we didn't discuss it in detail. You can have it in your Ignou textbook. There is all the fundamental rights are enlisted in your Ignou textbook, or you can Google it. But some of the important areas I need to highlight in the fundamental rights, that J.S. Verma Committee. Now J.S. Verma Committee had been constituted to check the effectiveness of the fundamental duties, because fundamental duties are not justiciable in nature and it's not enforceable also. Okay, so how can people obey the fundamental duties? Because some of the fundamental duties are to honor our national anthem, national flag, and to cherish our culture, etc. Such kind of fundamental duties are there. If people are not doing so, it would be what creating a great havoc in our country. So how could, so if we can't make the fundamental duties justifiable or enforceable as that of fundamental rights, then how it can be implemented so effectively? J.S. Verma Committee had told that no need to make fundamental duties as enforceable as it is no need to make fundamental duties as enforceable as fundamental rights, because explicitly through some other legislations passed by Parliament and various states, fundamental duties are being preserved. For example, is that Preventions of Insult to National Honor Act of 1971 prevents anyone to insult national honors like national anthem, national flag, etc. That is one thing. And this Prevention of Insult to National Honors Act of 1971 had come in the light of a very famous case known as Binoy Emmanuel West State of Kerala case. In that case, a petitioner was came across the Supreme Court and said that due to religious belief, one can't stand or pay homage to the national anthem. But the court, so what happens is that the parliament had seen a kind of a premonition by this petition. So they felt that the national anthem, national flag, and national honors, symbols of national honors, could be what disrespected. So what the government had done is that they passed this act in order to eliminate such situations. Now, Wildlife Protection Act of 1972 is also an important thing because one of the fundamental duty is to protect our environment also. And Forest Conservation Act is also dealing with the environmental conservation also. So with this, I am concluding my session. So hope you understood, hope you have enjoyed this section, and you have a nice day.